Advocate, Rajasthan High Court. He is a computer science engineering graduate with an LLB. He has worked in several leading companies, some of which include TCS, Goldman Sachs, and so on. He is a practicing advocate for civil, criminal, money laundering, constitutional, property, arbitration, matrimonial, sports, cyber, and labor laws. He has dealt cases under several jurisdictions, namely Rajasthan High Court, Madras High Court, Delhi High Court, National Consumer Dispute Redressal Commission, New Delhi, and so on. He is a great social worker and conducts legal awareness programs. He has sensitized more than 1,600 girl students on their legal rights. Let's give a round of applause for this. He is a regular speaker in various legal seminars for professionals, law students, and public at large. Mr. Ajay Singh will deliver his speech on global perspective. This is a pre-recorded session.
Honorable Dr. Justice S. Vimlaji, former Judge of High Court of Madras, Senior Advocate A. Tyagarajanji, Shri Balu Sir, Secretary Cyber Society of India, Shri Vijay Kumarji, President Cyber Society of India, all the members of Cyber Society of India, dignitaries on the dais, off the dais, and who have joined us online, and wonderful audiences who have joined us online, offline, both ways. It has always been a matter of great pleasure for me to participate in the events organized by Cyber Society of India. However, this time I am not fortunate enough to be present in Chennai to participate in this event. My association with Balu sir has been for almost 5 years now, and this is my fourth participation in a seminar, but for the first time I am connecting online. At previous occasions I came to Chennai, and I must congratulate Balu sir for making persistent, relentless efforts to spread awareness among public and to save them, to safeguard them from online frauds and all these things. The topic that I will talk about is global perspective in account freezing orders in cybercrime. So in next almost 12 to 13 minutes, I will try to give you a picture that the account freezing order is not confined to an individual. It has the potential of affecting the entire society, and the purpose would be to have a bigger picture that how these account freezing orders may become an hindrance in the aim of becoming a cashless society where we transact through banks. So first, talking about the global perspective, let's talk about what's happening in United Kingdom, because most of our legislations were enacted in British times, many of which are continuing even today. So let's see how they have traveled so far in developing a civil society, how they value the rights of an individual, and compare it with how we are also dealing with the same issue. In United Kingdom, the account freezing order is to be obtained from the magistrate court. So if an investigating agency wants a freezing order for a bank account, the investigating agency has to approach the magistrate court. They have to satisfy the magistrate court that the urgency is such that there is a suspicion that a account has proceeds of crime, or it has something which is recoverable, and the urgency needs freezing order. Now, the magistrate may, in its discretion, issue a notice to the person whose account is sought to be frozen. The magistrate may give him an opportunity to understand and to get his reply whether his account needs to be frozen or not. Unlike in India, let's compare it with India also. In India, the police would invoke 102 CRPC and tell the bank that this is the account which is suspicious and there is need to freeze it. The bank would freeze it. So the distinctive feature is that there in United Kingdom, the investigating agency is approaching the magistrate court. The magistrate court may give an opportunity of hearing to the person whose account is sought to be frozen. And after giving that opportunity of hearing, appropriate order may be passed. The magistrate may also grant account freezing order ex parte on interim basis, and the other person whose account has been frozen would have time to file reply and set out his case. But in India, the person gets to know about the freezing of account only after it's frozen, and it is done in a snap of finger. Like police is telling the bank, we need freezing of this account, the account is frozen. It is so surprising that the person is not even aware there are many things, living expense, many expenses are to be met out, and this freezing order is passed in such a casual manner. Also in United Kingdom, they maintain a minimum threshold of 1000 pound. It means a bank account should have at least 1000 pound, only after which they would decide whether to freeze it or not. So it's roughly 1,05,000 in Indian currency. Whereas in India, to my knowledge, there is no such threshold. I came across clients who told me that their account was frozen. And when I told them the legal procedure and the legal fees, they said that the account does not have that much amount to even meet out the legal fees. And the legal fees was very reasonable and very modest. So that kind of situation is also arising where the people have such a negligible amount in the account that they are confused whether to get it unfrozen or not. So my take is that police time is wasted, resources are getting wasted, inconvenience is caused when you do not maintain a minimum threshold amount, and all the accounts are getting frozen whenever a complaint is received. So in United Kingdom, another thing is there that the freezing order has a lifespan. It is usually up to applicable up to 3 months, 6 months. It may be extended to 2 years. A renewal is to be sought, and only after that it can be renewed. Whereas in India, it is frozen. It is frozen. Like one of my clients' account in Jaipur got frozen because of a complaint in the cyber cell of Hyderabad. Now that client is persistently trying to coordinate with the Hyderabad police, but many months have passed and till now no solution has been obtained till now. So these things should be learned from the system which is prevailing in United Kingdom. They also take into consideration, that what are the living expenses a person has to meet before a magistrate passes the account freezing order. It is taken into consideration that whether the entire account needs to be frozen or just a restraint order is required to be passed. For example, if the investigating agency says that in this account 5,000 pounds is unlawful, so a restraint order would be passed only up to the extent of those 5,000 pounds, and the rest of the account would be free to be used. Good thing is that in India also, now I am coming across clients whose entire account has not been frozen, but only a hold is created on the disputed amount. Like if 5,000 is in dispute, then a hold would be created only on 5,000, and rest of the account would be free to be used. This is a positive development, it's good. Now next example would be of, I will take is of Australia. In Australia, even an individual can approach the court to get a freezing order for someone else. So employer, if he has a doubt that his employee is involved in some unlawful activity and generating money, the employer may get a freezing order against the employee. So This is what is happening in Australia, and another debate is also growing there, and it's very logical. See, on one hand, we want our society to become cashless. So, cashless means your entire amount is in the account. And imagine the account freezing orders are just getting passed in snap of a finger. So, on one side, you are saying go cashless. On the other side, we are seeing examples where accounts are getting frozen with just intimation from the police to the bank. So how it would be possible for people to have confidence that yes, we should proceed towards the cashless economy when such threats of cyber fraud and account freezing orders, such threats are existing. People would definitely want that there should be cash in hand. If something happens, only cash is going to help. That kind of fear may be there, and that is what is people are debating in Australia also. Another example I would take is of Canada. Now, a few years ago in Canada, there was a protest. I would not go into the details. What was the cause? Were the protesters right in their demands or anything else? The relevant thing is that during that protest, the protesters would park their trucks and larger vehicles on the road, creating a blockade. So it would be difficult for the government agencies to enter into that area. So the Canadian government enforced the Emergency Act of 1988, and thereby they gave power to the bank to freeze the corporate account of the owners of those vehicles. Suppose something is someone is doing a protest for a right cause, and state is exercising power like this. I'm not talking about Canada only, but I'm just taking an example. Imagine a situation if the government takes such measures to deal with the protesters. It would be really worrisome for the civil society, and it would be worrisome for a democracy to think of such situation. Then a Canadian government also gave power to suspend the insurance of those vehicles which were used by the protesters. It is also again a very big threat to the financial situation of any owner of vehicle if his insurance gets suspended. And they also looked into that which platforms were helping protesters with crowdfunding, how the funds were gathered from the public and given to the protesters. So the platforms which were involved in that of crowdfunding to help and support the protesters, they also got a threat of account freezing. This example shows that account freezing is not to be dealt with or confined in a narrow scope of its effects on an individual. The bigger picture would be to see how such orders can, affect the entire society. In Malaysia, recently, a kill switch feature has been introduced by banks, which means that if a person is suspicious of some fraud which is going to happen in his account, he may press the kill switch, his account would be frozen. So I was just thinking, well, what would be the life switch? Because if we freeze our own account, how difficult it would be to get it unfrozen and get it alive again. And my say would be that global perspective is that account freezing orders need to be passed in a very careful manner. In India, we need uh, intervention of courts in such matters. After freezing of the account, people approach court. That is already there. My say is that even before an account is frozen, there should be an opportunity of hearing to the person, his account may be freeze, maybe a freezing order may be passed without hearing him on a temporary basis, but within a short span of time, that person should be given an opportunity of hearing. That is what we can learn from the procedure which is adopted in United Kingdom. And that is all I have to say. Thanks to Cyber Society of India, to dear Balu sir, Vijay Kumar ji, for giving me this opportunity to share my thoughts on this topic. And next time, hopefully, I would get an opportunity to meet the legal luminaries like Honorable Dr. Justice S. Vimla ji and Senior Advocate A. Tyagarajan ji in person, and all other wonderful people there whom I have met in previous seminars. I am missing you people. Anyways, I was able to join online. I am thankful for that. Thank you so much. Namaste.